just about pressing it.
Sorry about that.
That's all right.
Is that okay?
I'm bound to spill it. But
About.
David Locke, QC, on behalf of the core participants represented by Leigh and Co.
Thank you very much, Sir Brian. Ladies and gentlemen, I don't have very much voice thanks to the ravages of a cold, so I'll do my best. But I have the privilege, and it is an enormous privilege, of being instructed by Leigh, together with my own friend Miss Hannah Gibbs, on behalf of 251 victims of the infected blood scandal. Many of our clients are active members of the Contaminated Blood Campaign, CBC, and Leigh have given pro bono legal assistance to the CBC for about the past 4 years. We have been involved in a series of challenges to the chaotic and ad hoc ex gratia payment schemes, and along with a number of other people, have been responsible for the challenges which led to the present changes, not enough change, but at least some change, to the schemes. The one thing which links all our clients is that they are or are related to individuals who became infected with hepatitis C or HCV as a result of NHS-contaminated blood or blood products. But despite this unifying feature, every one of our clients has suffered in different ways for different reasons. And that's a reflection of the devastatingly large reach of the contaminated blood scandal. Some of our clients contracted hepatitis C and continue to carry the virus. And they've developed very significant physical, psychological and cognitive disabilities as a result of carrying the virus in their bodies for decades. Others contracted hepatitis C, and after undergoing one of a number of deeply unpleasant and painful treatments over a period of many months, have been cleared of the virus. But the fact that the virus is no longer detectable in their bodies does not signify an end to their suffering. Many of these individuals developed very significant disabilities as a result of carrying the virus. Medical treatment may have cleared the virus from their bodies, but they've been left with the permanent, significant physical, psychological and cognitive disabilities. Some of our clients are relatives of victims who contracted the hepatitis C virus from NHS-contaminated blood or blood products, many of whom are now deceased. In all cases, the relatives have seen their loved ones suffering significant disabilities and developing serious conditions which in many cases led to a painful and distressing death. Some of our clients are co-infected because they carry the HIV virus as well as hepatitis C, or they're relatives of people who are or were co-infected. And it's important to emphasise that the impact of the infected blood scandal on many of our clients is not limited to HIV and hepatitis C. They have been exposed to a wide range of other diseases and received warning letters that suggest they may carry dormant pathogens for which there is no test, such as new variant CJD. For those who are not familiar with this disease, new variant CJD is a prion disease for which there is no cure. There is strong evidence that it is caused by the same agent that led to the outbreak of mad cow disease. Many of you will remember the utter shock when it was discovered that mad cow disease was affecting humans, and the climate of fear associated with beef products. The worry that those who ate beef might develop symptoms of this incurable and terrifying disease was widespread, but thankfully few in the general population have shown signs of the condition. But in contrast, the real risk of developing CJD is something our clients have to live with every day. The continuing psychological impact of these unknown risks is difficult to overestimate. So is the distress caused to our clients by the need to explain every time one of them visits a hospital or a dentist that there is a risk of transmission. And we strongly welcome the fact this inquiry recognises the victims are not limited to those who were infected with the viruses, the result of NHS contaminated blood or blood products. All our clients live in families. They all live in communities. And the impact of this disaster has spread through families and communities. Poetry was used to great effect in the commemoration yesterday. But my clients have asked me to refer to another poet, to John Donne, whose words famously set out how they feel. He said, "No man is an island entire of itself. Every man is a piece of the continent, a part of the main. If a clod be washed away by the sea, Europe is the less, as well as if a promontory were. As well as any manner of thy friends or of thy own were. Any man's death diminishes me, because I am involved in mankind, and therefore never send to know for whom the bell tolls. It tolls for thee. The bell has tolled for many men and women, all victims of this tragedy. The victims include parents, family members, carers and friends of both the living and the dead. Some limited recognition has been given through the haphazard and grudging way the ex gratia compensation schemes have been set up, but in the main, they've only offered support directly to the affected victims. My clients asked this inquiry to be the first occasion on which there is formal recognition of the devastating impact this disaster has had on parents who've seen their children suffer terrible disabilities or die at far too early an age, or those devoted spouses and carers whose entire lives have been shared by their commitment to a victim. We thus welcome the recognition the inquiry offers in its focus on all those whose lives have been affected by these terrible events, only some of whom are actually infected. And we also welcome the fact the government has finally agreed to set up this formal public inquiry, and our clients are determined to do everything they can to assist you, Sir Brian, as chairman of the inquiry, and your staff, to undertake the almost impossible job of peeling away the obfuscation, the delay and the denial which has characterised the official response to this tragedy over the past 3 decades. There are a series of specific points our clients want me to make on their behalf, and I'm delighted to do so. First of all, the terms of reference. Our clients want to welcome the width of the terms of reference, but they also welcome the fact that the terms of reference for the inquiry were agreed following a wide-ranging consultation. They are grateful they have their voice heard in setting the terms of reference. And you will expect our clients to be rigorous, ensuring that you investigate comprehensively across the whole range of issues raised by your terms of reference. Now, we understand the need for expedition, but we have very clear instructions that full respect is given to the width of the terms of reference, and no attempt is made to cut them down for administrative convenience or to spare the embarrassment of those whose administrative decision means they discovered to be key players in the sequence of events that led to the tragedy. And that brings me to the second point that the victims I have the privilege of representing wish to raise. That is, how should the inquiry approach individuals who have been involved in these events but can no longer defend their action? Many individuals who are key decision makers will no longer be able to defend their own reputations because they are deceased, long retired, or have no memory of the relevant events. We appreciate there will be an enormous temptation to protect the reputations of those who cannot speak for themselves because they're deceased, because they're living in retirement, because they cannot be expected to recall events of many, many years ago. And our clients do not want this inquiry to turn into a witch hunt. But the evidence is likely to show reckless, uncaring, incompetent, or wholly inappropriate behaviour by NHS and government decision makers. And we invite the inquiry to follow the evidence chain wherever it leads. The inquiry process should not hold back from investigating what really went on, what decisions were made, what risks were ignored, what errors were committed, even though this may result in reaching some difficult, unpalatable, or appalling conclusions which will affect the reputations of individual civil servants, ministers, doctors, or NHS officials. And the reason for that is that public officials working for public bodies, whether in government, the NHS, or elsewhere in the public services, must be held publicly accountable for what they did or did not do. Now, my clients fully accept any judgment must be based upon the information available to a decision maker at the time. But legitimate questions, we think, should be asked about what the individuals knew, what inquiries he or she made to establish the truth about the risks or benefits of a course of action, and what he or she ought to have known before making key decisions. And we hope this inquiry will not refrain from holding public servants properly to account for their acts and omissions merely because the individual is deceased or cannot now recall the circumstances which led to the decision in question. We accept there will be a fine line to tread between appropriate respect for those who cannot speak for themselves and proper transparency and accountability. But in treading that line, we urge the inquiry to bear in mind that every employee of a government body knows and has always known that he or she will be called to account for the discharge of his or her public functions at an undefined date in the future. The function this inquiry will be undertaking of scrutinising decision-making of public bodies carried out by individuals is one that all public officials know is possible because public officials are accountable to the public for their actions just as they are paid by the public for their services. Accordingly, whilst we are always seeking to be fair to protect the reputations of those who cannot speak for themselves, we expect the inquiry to be rigorous in exploring precisely how the decisions were made by named individuals which led to the thousands of deaths of wholly innocent NHS patients, and how the lives of so many others came to be permanently blighted by serious physical, psychological and cognitive disabilities, and the balance of interests between transparency and the protection of reputations. We expect no stone to be left unturned, however much unturning that stone reveals events which demonstrate incompetence, a lack of understanding, inadequate inquiry before decisions were made, shortcomings as a result of resource constraints, plain incompetence, or worse. Now, my clients respect the inquisitorial nature of this inquiry. We won't seek to routinely cross-examine any witnesses. We may suggest questions to be put by counsel to the inquiry, but except for the most cases, the choice of questions must be a matter for the inquiry team to decide. But there will be a small number of critical witnesses where we will be inviting the inquiry to take a different course. Where a key senior decision-maker is giving evidence, we will be inviting the chair to accept that our clients will want to hear that senior decision-maker answering their questions put by their chosen representative. Next, I need to say something about disclosure. On the 29th of March 1991, the inquests into the deaths of 96 football fans who died at Hillsborough returned a verdict of accidental death. That judicial process was in part informed by the outcome of a report by Lord Justice Taylor into the tragedy. Those two processes were both utterly inadequate to get to the truth of what happened at Hillsborough, primarily because of inadequate disclosure of the records made at the time by all the relevant individuals who had a part to play in the events, the tragic events of the 29th of March 1989. But the lack of disclosure did not stop there. On the 5th of November 1993, the Divisional Court refused an application for judicial review of the inquest verdicts. On the 13th of February 1998, Lord Justice Stuart Smith reviewed new evidence in relation to the tragedy at Hillsborough and recommended no action should be taken to reopen the inquests or commence investigations into possible prosecution of individuals whose decision may have led to those deaths. Those who were closely involved with the events knew that the official account was far from the truth. They knew the real story of events which happened at Hillsborough had not yet been told. The families of the 96 knew the truth had not been told, and they were a thorn in the side of the establishment for year after year as they made what seemed impossible demands to reopen findings made in an official report, in inquest, and in a judicial investigation. But, and this is the chilling lesson we invite this inquiry to focus on, the families were repeatedly right and the establishment was repeatedly wrong. The families campaigning eventually persuaded the government to set up the Hillsborough panel. That panel examined 450,000 documents in their quest to find the truth. Personal records by former police officers were obtained from lofts up and down the country. Legal professional privilege was set aside in the interests of finding the truth. Official documents were discovered for the first time, and they painted a very different picture to the story that had been told to Lord Justice Taylor, to the inquest, and to Lord Justice Stuart Smith. And eventually, on the 12th of September 2012, the Hillsborough panel published its report, properly informed by a vast number of previously undisclosed documents. That led to new inquests, which in turn led to the findings handed down by the jury on the 26th of April 2016, that 96 Liverpool fans were unlawfully killed. My clients are entitled to believe there are lessons that this inquiry can learn from the Hillsborough process. Now, very considerable credit needs to be given to the late Lord Archer of Sandwell, the former Solicitor General, who chaired the non-statutory inquiry into the infected blood scandal which reported in 2009. But there is a telling phrase in the Archer report where Sir Nigel Crisp is reported to have told Lord Jenkin, the former Secretary of State, that potentially incriminating documents relating to this disaster had been destroyed, quote, with intent to draw a line under the disaster. We understand there are reports that the private papers of the former Secretary of State, Dr. David Owen, were part of this destruction exercise, and that is clearly something the inquiry will want to investigate to ensure this type of exercise is never repeated by any government body in any circumstance at any point in the future, however convenient that might have appeared to the civil servants or the governments of a day. If it is true that civil servants deliberately destroy documents to draw a line under the disaster, the civil servants were the only individuals who could walk away from this disaster as a result of the deliberate act of wanton destruction of records. Our clients were required to live with the consequences of the decisions made by public officials for the rest of their lives, and many had their lives cut short as a result of those decisions. But the reality, as you will know, Sir Brian, as your inquiry team are trying to find out, is that a single copy of a document is a rarity in government. The nature of government is that multiple copies of any significant documents are created. They're filed in numerous different places, and not every civil servant will have considered the deliberate destruction of documents was an appropriate policy response to this disaster. Our clients are confident it is possible to find copies of virtually all documents generated by the government in relation to this disaster, albeit it will be a painstaking, massive task. It will require persistence and ingenuity and will require the investigators to use all the skills and techniques developed in Hillsborough and the Gosport inquiry. But we are confident that a thorough document disclosure process will assist in uncovering the whole story. And we therefore welcome the clear statements by Jenny Richards QC yesterday that the inquiry has an expectation that public bodies responding to its request for disclosure will waive legal professional privilege. Legal professional privilege should not be used as a shield to prevent those who are paid by the public from being accountable to the public in this inquiry. We hope the government will accept whatever the embarrassment or the potential financial cost, the time for secrecy about what went on is over. Just as legal professional privilege can be overridden in the public interest under the Freedom of Information Act, something of which you'll be very well aware, legal professional privilege should not be raised to prevent the full truth being disclosed to this inquiry. And therefore we hope that the Department of Health and those acting for the various NHS bodies will put no obstacles whatsoever in the way of the inquiry team discovering all of the relevant documents. This inquiry only happened because of the tireless campaigning of a number of groups, including my clients, the Contaminated Blood Campaign, and many others. Now that it's set up, all public bodies should assist by providing all relevant documents so that this final chance to discover the truth can be as much of a success as it possibly can, however awkward or embarrassing those disclosures may be. Warnings, the fourth point. The terms of reference rightly focus on the sequence of events that led to this disaster and the information that was provided to the government that ought to have led to identification of the risks of using untested blood and blood products. Others have spoken of the need to establish precisely what public officials were told about the risks of importing contaminated blood, when those warnings were given, when they should have been given, and how the government and the NHS responded and why they delayed in acting on those warnings. It's clear that the failure to act earlier resulted in deaths and blighted lives. So we will support the inquiry in vigorously investigating how blood products came to be used in the NHS and why those warnings were not heeded. Fifthly, informed consent. The issue of informed consent lies at the very heart of any lawful medical treatment. Following the seminal judgment in Montgomery, informed consent has been established to be part of the common law, but it was always part of the common law. Montgomery did not change the law. The need for medical consent by a patient to be informed of the risks has always been present. And one important aspect of the risks that my clients are particularly keen to have investigated is the justification of treating people with bleeding disorders with massively pooled factor products. In particular, to understand the nature of the risks faced by those with severe, moderate or mild bleeding disorders. Because the inquiry needs to discover why NHS patients were exposed to the risk of contracting viruses from contaminated blood, and whether they were given proper information about the risks they were running, and particularly why they were exposed to those risks when there was no immediate or urgent need for the application of blood products. Some of my clients were affected as a result of regular prophylactic treatment that was meant to be preventative of future ill health, but in fact became causative of devastating disabilities, and the extent to which these patients had the risk of such prophylactic treatment explained to them or not explained to them is plainly an area for this inquiry to examine. Sixthly, the source of the infected blood products. There's been an assumption in some of the literature that all the NHS infected blood came from abroad, typically from US-based prisoners or those on the margins of society. However, it will be part of this inquiry to determine whether that is a largely correct picture or is a convenient myth. The extent to which inadequacies in our own domestic NHS blood collection service led to NHS contaminated blood or blood products will be a very important area for this inquiry. Seventh, disclosure to infected patients. This inquiry will wish to investigate why patients were not told about their infections, even when this knowledge was held by doctors. The evidence will show some patients had to wait many years before their diagnosis was confirmed, putting them and their loved ones and members of their families at risk. Whether, and if so, why, whether there was any systematic monitoring of patients with infections must be vigorously investigated. And in particular, was there monitoring of patients who were infected by the NHS without the knowledge or consent of those patients? Which brings us directly to the next point my clients want you to investigate: the attempt to deflect blame from the NHS. The inquiry will want to know why so many infected patients were accused of having acquired the viruses by drug taking, alcoholism, sexual promiscuity, or any number of other potential reasons. The experience of my clients is that the NHS was often keen to find any cause as to why individual patients carried the hepatitis C virus, rather than admitting the individual contracted the virus from NHS-contaminated blood. Those accusations appear to my clients to have been made on a systematic basis, regardless of the evidence of the supporting evidence in an individual case, and the damage of victim blaming cannot be underestimated. Next, treatment regimes. We support the inquiry examining whether victims have received the right treatments, particularly as those treatments have developed from research into clinical practice. Victims whose lives were blighted by the NHS decision-making have never been prioritised for emerging curative or symptom-relieving treatments by the NHS. The argument has always been advanced the NHS cannot prioritise the treatment of some patients who carry a virus over others who carry the same virus based on the underlying cause of the infection. But the inquiry will have to look to determine whether that is a morally defensible position or an appropriate way for the NHS to respond. That raises profound ethical questions. But in summary, the position of my clients is they are entirely blameless for the disabilities inflicted on them by the NHS, and they ought therefore to have been at the front of the queue for any emerging treatments. Medical records. I was interested in what Mr. O'Neill had to say about medical records. There is an enormous concern amongst my clients about repeated patterns of the NHS losing medical records relating to patients who've been damaged by the NHS's own actions. They do not accept for a moment that this loss of medical records from these patients was unrelated to the cause of their infections. This appears to them to be a case of the NHS getting rid of the evidence of the sins of the past. But if so, who organised it? Who made the decisions? The inquiry will want to look to see the extent to which this is supported in the evidence, and a culture emerged of losing records which were embarrassing to the service. Was this a series of coincidences, or was this a pattern of behaviour by NHS bodies in an attempt to limit the reputational damage to the health service? Next, the role undertaken by other parties. Now, the main focus of this inquiry will undoubtedly be on individuals working for the government, ministers and senior officials for the NHS. But there are a very large number of other bodies whose actions or omissions played a significant part in this sequence of events or influenced disproportionate, unbalanced or inappropriate responses to the tragedy. The prioritisation of one group of victims over another may seem entirely justifiable to someone who's promoting the cause of that particular group of victims. And it's easy to see objectively different victim groups have been treated differently. But this is utterly indefensible and is a part of the sorry history of this tragedy. The focus, we suggest, should not be on those groups who acted for victims and who are pressing for and acting in the interests of those they represent, perfectly properly. The focus must be on government decision-makers who had a duty to all victims, and we suggest failed to act equitably between different categories of victims. Next, mortality rates. That a different approach is taken to different victims is perhaps illustrated best by the absence of any comprehensive analysis of different mortality rates across the different viruses caused by infected blood and infected blood products. My clients hope the inquiry will, for the first time, be able to gain a full and complete picture of the mortality rate within our infected community. To do so will require a detailed analysis of the data held by the 5 previously separate ex gratia schemes, and this information will need to be collected in a way to show how the mortality rates of the infected community have changed over time. And there are 5 specific categories we would urge the inquiry to focus on. Co-infected patients, HCV patients at stage 2, co-infected patients at HCV stage 1, mono-infected patients at stage 2, mono-infected HCV patients at stage 1, and of course mono-infected HIV patients. And the mortality rates will be different between those groups. 13th point, we're nearly there. Support for spouses, partners and victims. It is mystifying as to how anyone in government could have thought it was appropriate to provide financial support to spouses, partners of children who died as a direct result of acquiring one type of virus from NHS-infected blood, but to deny a similar level of financial support to spouses of partners or children of individuals who died as a result of acquiring a different type of virus from the NHS. Until very recently, that was how government public money was used across the various schemes. And this inquiry will want to look to see how that utterly indefensible set of circumstances emerged and why it took so long before that obvious disparity was corrected. Looking forward to the end, it is a sad but inevitable fact that some of my clients will not live to see the final report produced by this inquiry. They have already had to wait far too long, but for some, they will never see the final outcome. There is a balance between urgency and the need to be comprehensive. We do not urge the inquiry to restrict the scope of investigations in order to produce a report too quickly, but we equally commend the steps that have been taken to proceed with the inquiry as expeditiously as possible. But can we invite the inquiry now to focus on and to set the ground rules that will be taken following the end of the evidence? My clients are particularly concerned this inquiry should learn the lessons from other public inquiries where there have been very extensive delays, sometimes running into multiple years between the conclusion of the evidence and the publication of a final report. Some delay is inevitable and proper. Other public inquiries have been dogged by disputes, endless disputes, often litigated in the court, where individuals seek to prevent the inquiry reaching conclusions with which they do not agree, or to being subject to criticisms which they do not accept. Now, the trigger for this post-evidence series of confidential disputes has been the practice of sending warning letters, known as Salmon letters or Maxwell letters, to individuals whose conduct is proposed to be criticised in the final inquiry report. However, that process is confidential and is thus inherently unfair to the other participants who are excluded from the debate about the extent to which any individual organisation is being criticised. Now, individuals who give evidence in a court of law do not have the opportunity to debate the merit of the judge's conclusions before the publication of a judgment. The judge discharges his or her functions by ensuring fairness within the process, but there is no requirement for an additional sequence of events before judgment is handed down. And given the need that this report should be published as quickly as possible, and given the unfortunate experience of other public inquiries, we invite the Chair to indicate now that fairness to individuals and organisations will be discharged within the inquiry process and not by way of warning letters sent during the writing up phase. We accept this may, on occasion, mean the inquiry recalling individuals to give further evidence or organisations the opportunity to answer criticisms which emerge at a later stage of the evidence. But that process has three advantages. First, it's fair and gives due respect to the rights of all participants. The confidential debate and subsequent litigation arising from warning letters is unfair to other participants by the very nature of the confidential process which is being undertaken. Secondly, not sending warning letters, perhaps save in exceptional circumstances, will speed up the process between the end of the evidence and the publication of the final report. And thirdly, it will ensure that all relevant debate on material issues meets the high standards of transparency and accountability to which this inquiry has rightly committed itself. And therefore we invite the Chair to reflect on whether this is an area where he considers to set out the ground rules at the outset of the inquiry. So, Mr. Chairman, in summary, our clients have lived with this blight over their lives for decades. They have repeatedly knocked on the door of government to ask for answers, knowing that every year that passed would make the task of finding those answers more difficult. This will be their final chance of securing truth and justice for those who are living, albeit they are still suffering profound disabilities as a result of the tragedy. It's also the final opportunity to recognise the extent to which lives were cut short for those victims who've died before they had the chance to take part. There will always be errors in organisations as complex as the NHS, and this inquiry has the opportunity to identify the monumental errors that were made in relation to infected blood and blood products, and to lay bare the decision-making process which failed to prioritise the interests of patients over the system and led to those errors remaining uncorrected for too many years, with the disastrous consequences that everybody knows about. And the sincere hope of our clients is that future generations of NHS and government decision-makers will understand what went so tragically and repeatedly wrong in relation to NHS-infected blood and blood products. Now that, of course, does not guarantee that future decision-makers will not follow a similar course in future. But the legacy of a report which understands how and why things went so terribly wrong will very substantially reduce the chance of another tragedy. So, Mr. Chairman, our clients will endeavour to see this process through as a cooperative venture between everyone involved, with the focus on establishing a comprehensive account of who, how, why, when and where decisions were made that blighted the lives of thousands and led to so many premature deaths. We will be supportive but critical friends of the inquiry, holding it to account and playing our part in getting to the truth before it is too late to find out the truth.
Thank you very much, Mr. Locke. Our next contributor is Michelle Tolley. It's fresh. I didn't think you'd think about it.
Okay, thank you very much.
Is that okay for you there?
Yeah, that's fine.
Because it goes up.
No, that's fine.
Pretty good.
Yeah, that's fine. Yeah, thank you. Well, good afternoon, everyone. Sir Brian, inquiry team, members of the press. My name is Michelle Tolley, and I'm 53 years old. And I run a wonderful support group called Contaminated Whole Blood UK, which I'm very proud of. My story. I had 2 blood transfusions, one in September 1987 and the second in February 1991, after childbirth. During the mid-90s, there was some campaign that came on the TV regarding bloods that had not been screened, HIV, where you could have been infected by tattoos, dentistry, operations abroad, blood transfusions, and several other methods. I telephoned the number, received the information through, and dutifully went along to see my GP at that time with my worries and concerns, as I was already feeling severe fatigue. I went along to my GP, explained that I had severe fatigue, in which he replied, "Well, of course you have. You've got 4 young children. What do you expect?" I then spoke about the adverts I'd seen on the television and my concerns that I'd had 2 blood transfusions before the bloods were screened. His reply to that was, "Don't be silly. Of course you won't have that." Now, when you're a young mum responsible for 4 children, you look at your health professional with trust that they are telling you the truth. And I jollied along on my way, still very tired. Apparently, there was a look-back exercise to try to identify those who may have been infected. Well, they didn't look very far, did they? As there are so many of us infected victims who still do not know today that they've been given a death sentence without even committing a crime. I was finally diagnosed in November 2015 by chance, and with a new GP, I might add, that I did in fact have hepatitis C. The impact on our lives has been one of devastation, destruction, and ultimately death. The ripple effect from innocent infected victims to the innocent affected victims has seen children, brothers, sisters, aunts, uncles, cousins, mothers, fathers, husbands, wives, grandparents, in fact, in some cases, a complete generation lost. But this wasn't only whole blood. Of course, there were blood products. What was the cause of this bloody mess? Blood products, such as factor 8 and factor 9, were also responsible for not only hepatitis C, but hepatitis B, HIV, and other pathogens, which killed thousands of innocent lives. Those responsible for this historic and horrific tragedy, which has lasted decades, must be identified. They must be held responsible for the consequences of their actions and prosecuted if necessary. Just to finish off, I would like to send my sincere thanks to the love of my life, my husband Dean, who has been my strength and my support and believed in me and given me the courage to come up and speak out in front of everybody. To my lovely family for being very understanding also, but also to the members of the various groups that I belong to, but especially to those from Contaminated Whole Blood UK, and also to the Hepatitis C Trust, who have been my friend and ally throughout. Thank you.
Thank you, Michelle. Paul Desmond.
Thank you, Brian. Good morning. First of all, I'd like to start with a question. I recently read an August 2018 comment from a Department of Health spokesperson that went, hepatitis C infections from blood transfusions were an inadvertent, unavoidable accident, for which the terms liability and compensation are inappropriate. Does anyone in this hall agree with that statement, that it's an accident, that it couldn't have been done better, that no one made a mistake? Does anyone agree? Not a single hand. That's what I thought. So, a quick statement about liabilities or things that went wrong in the Department of Health. due to running a medically negligent, filthy blood supply from 1970 to 1991 seems urgently needed. Firstly, the planned avoidable harvesting of hundreds of thousands of units of blood from British prisons was no accident, and it was a negligence avoided by many, many nations. It is a joy to see our inquiry lawyer laptops ablaze with data detailing the mass harvesting of highly infectious hepatitis C prison blood in the UK. This went on until 1985, at which time Dr. Doe harvested some samples and kept them. In 1991, when the test became available for Hep C, he found prison blood was 65% hepatitis C positive in his samples. This goes a long way, those 500,000 units from prisons, to explaining our peak of 585,000 hepatitis C patients in 1985. That's the first negligence. Second negligence. There was a complete failure in the UK to surrogate blood test for liver disease markers, blood donations. This was planned, and this was no accident. The Gunson report, studied by our transfusion service head executives in 1985, estimated 40%, or 8,000 of our annual 20,000 hepatitis C transfusion infections could have been avoided with surrogate blood screening. Third negligence. There was an idiotic notion prevalent in the blood executive, the working party, that hepatitis C was benign. This idiotic notion was unique to the UK, and it was also created, defended, and certainly no accident, and it did not happen in other countries. Fourth negligence. The use of pooled plasma factors, bought sometimes from overseas, was chosen over safer alternatives and was also definitely not an accident. All the above plans were chosen by our blood service and often avoided elsewhere. We were agonisingly slow in stopping prison blood harvesting, completely out of step at safety testing for liver disease markers, our donations, and even amongst the last in the developed world to initiate ELISA blood testing in September of 1991. Moving on. I've been asked by the inquiry legal team to just touch on numbers infected with Hep C via NHS care, and this time we truly need to get to the industrial scale of our contaminated healthcare disaster and get it admitted and get it cared for. To make it crystal clear, every report from experts in the 80s before the cover-up, every survey done on testing the transfused, including thousands of blood tests done on the transfused, and every one of the 3 internationally respected models for counting transfusion hepatitis in a country, all 3 models suggest we had approximately 300,000 infected transfusion survivors in England in 1990. I'd like to very much thank our inquiry team for building an expert statistics group that will, of course, drill into this suggestion. And also for bringing global figures such as Dr. Penny Chan, who are completely independent and more than able to add up these numbers on our behalf in the near future, I hope. Simply speaking, for the lawyers, laymen and press present, one method to count a nation's contaminated healthcare outbreak is called the per transfusion method. You work out how many transfusions a nation did, what percentage were infectious of Hep C, and there you have your number. In the UK, Every report suggests our transfusions were 1 in 40 infectious or 2.4% infectious. We did 12 million transfusions from 1965 to 1985. 2.5% of 12 million transfusions gives you approximately 300,000 survivors in 1990. With this method, France noted 400,000 survivors in 1990, infected at a rate of 40,000 a year. In the US, they noted 2 million survivors, infected at a rate of 250,000 a year, and this method gives us 300,000 UK survivors in 1990, infected at a rate of 20,000 a year. And that figure was studied by our blood service in the 80s. Sadly, in the UK, we have pretended transfusions were 1 in 2,000, 1 in 500 infectious. This wild speculation from spin doctors has created this figure of 28,000 infections. 28,000 is 15 times less than the EU national average, or the numbers reported by Spain, France, Italy, the USA, and Poland, to name a few. Another method to understand transfusion infections is called the population prevalence method. With this method, you count the number of people with hepatitis C in your country, you subtract those from injecting drug use and other causes, and that leaves you your contaminated residue. In the UK, there could not have been more than 200,000 injecting drug user infections in 1990. This is according to police reports at the time. And 85,000 infections from other causes. 285,000 from our 585 figure gives us, again, 300,000 NHS healthcare survivors. The third method is testing of population cohorts. And here, suspiciously, alone in the developed world, the UK has never mass tested its C-section or high bleed maternity mothers. It has never tested its child surgery or blood product given children. It has never tested its dialysis, its transplant, or comprehensively tested its trauma patients. This hall is full of patients who had to wait 5, 10, 20, even 30 years to stumble upon a diagnosis. However, some smaller studies have been done in the UK of the transfused, and they note, when tested, 1 in 50 transfused children had hepatitis C. They also note 1 in 14 dialysis patients, when tested, had hepatitis C. They also note that heart patients, when tested, were 2% hep C positive. They also note that thalassemia major patients receiving 100 units of blood were 100% infected. This level of infection again suggests a far higher level of hepatitis C infections from the NHS's healthcare than we have been led to believe. Finally, on numbers, 28,000 is a figure offered by the only Department of Health in the world to have systematically refused to mass warn and test its patients. It is a figure offered by the only Department of Health in the world that lost 2 entire tranches of ministerial-related notes. It is a figure offered by the only Department of Health in the world to force a settlement out of court on the handful diagnosed in 1990. None of these are the actions of a health service searching for the truth and infected patients. All of these are the actions of an organisation covering up the facts. Finally, a brief statement about the UK cover-up of the World Health recommended guidelines for testing. In the 90s, as France rushed to diagnose 80% of its 400,000 survivors, in the 90s as the USA rushed to diagnose its 2 million survivors, our several hundred thousand NHS contaminated healthcare survivors have simply been lied to and denied a safety test warning. Most of them have even been denied the fact that they exist. As the World Health rushed to air its stop, caution, get tested message globally and find the 100 million plus infected via transfusions and healthcare, and rushed to warn them that 21 units of alcohol can kill them, that many modern common prescriptions like paracetamol can kill them, our health service did next to nothing. In 1995, in fact, our chief medical officer, Dr. Kalman, simply stated, instead of 500,000 people having Hep C, in his letters to GPs and hospitals, he said it might be just 50,000. It might be 250,000. We don't know. From that point on, hundreds of thousands with contaminated blood from healthcare in their veins were left to die as soon as possible. It should be remembered that in France, doctors were imprisoned for the crime of even thinking of leaving people in such danger, as ours were left in for decades. Dr. Kalman also stated in his letter to the GPs and the hospitals, there are reasons, wait for this one, there are reasons when it is preferable not to inform patients of their transfusion Hep C infections or risks. He refused all testing to those infected from 1945 to 1987. In fact, not until the hepatitis scandal report was tabled in the Commons was any effort made to create a national Hep C testing strategy in 2004. Contrast this with the 1990s contaminated blood statement of the US Surgeon General in the early 90s. Dr. Everett Koop stated to the American people in the world, "We stand on the precipice of a grave threat to our public health. It affects people from every walk of life. It affects people in every country. And unless we do something about it soon, it will kill more people than HIV/AIDS." Our Department of Health spin doctors, when finally bullied into making a plan, more than a decade later, decided they needed a small, low-key campaign aimed at not being sensational and focusing on highly marginalised addict groups. We need to just admit that the UK tripling of cirrhosis and liver cancer in a time of falling alcohol use is motored by our cover-up of the fact that 1 in 100 UK citizens had a deadly liver carcinogen called Hep C at the end of our harvesting blood wholesale from prisons. This worst in the EU boom in liver death is mirrored by our worst in the EU effort at diagnosing our contaminated blood survivors. Sadly, this boom was actually predicted in the Commons in 2002 in the hepatitis scandal report, and by myself again to Lord Archer in 2007. We need to realise also that as fast as we have left 300,000 NHS survivors without testing, we have imported up to 200,000 more survivors from contaminated healthcare from overseas with hepatitis C and hepatitis B. We need to understand if we have lost 20,000 lives to this disaster and its cover-up, we cannot afford to lose another similar number. It doesn't matter if we have an advanced cure for Hep C. It doesn't matter if we have treatments for Hep B and transplants for both, if we don't have the truth to warn people they're infected. Finally, I'm sorry if this is a little adversarial, but our healthcare services harbour a few key Department of Health quangocrats who have run this cover-up and who see it as their job to protect their organisation and its reputation and perhaps their pensions. We need to claim our health service back from these people and give it to doctors who want to save lives whatever the cost. We know who these quangocrats are, and I hope we'll hunt them down for questioning, and I sincerely hope punish them after extracting some confessions from them. It may be blood for blood, but it is also justice. Thank you.
Well, ladies and gentlemen, something like 10 minutes early, we are breaking for lunch. Can I ask you, therefore, please, to be back here by 2 o'clock rather than the 2:05, which is on the programme. I shall see you then.